The Judicial Council website is a very helpful place to start to gather information. Their section on guardianship of children in probate court helps you learn about guardianship and alternatives.
Here we are at the Self-Help Center for the Judicial Council.
Okay, great.
Should be great information in there.
Ah, there we go. What is a guardianship?
Okay.
Okay. Guardianship is a court process by which a person other than a parent is given custody of a child or authority over a child's property. Appointment as a guardian requires the filing of a petition and approval by the court. To be appointed a guardian, you must be at least 18 years old, and you must have filed, petitioned, and be approved by the court. Well, that sounds like me.
Yes, and actually a relative or non-relative could file for a petition for guardianship in the probate court. The only difference is that a court investigator would meet with a relative, whereas a representative of the Child Protective Services would meet with a non-relative, like me.
Yeah, I remember that meeting with CPS really well. And that was the day that Will decided to fall off of his bike. Girl, remember that big old egg on his head and the bruise?
I don't know why he had to wait until that morning to fall off that bike.
But you know, I'm just glad they believed you.
Well, me too. But before you file for a petition for guardianship, you should check out your alternatives. You can make a private written or verbal agreement with the parents, where the parents agree that you have physical custody of the children. But this does not create a custody order that would allow you to legally enroll the children in school or authorize hospitalization or treatment in medical emergencies. And parents may choose to end a private agreement at any time.
Here's the caregiver's authorization affidavit. The California Family Code allows a person who is related to a child to fill out a caregiver's authorization affidavit. The affidavit normally allows that person, as a caregiver, to enroll the child in school and secure medical treatment for the child. That sounds good.
Yes, it does, but read further.
The parents may revoke this authority or override the caregiver's decision under this agreement at any time. And the caregiver's authorization affidavit is valid for just a year.
The power of attorney is useful if the proposed guardian lives out of state and wants temporary authorization from the parents. But the parents may revoke the power of attorney at any time.
Gladys, now you know my daughter's troubles. I want to be able to protect my grandkids and keep them in my custody.
With the guardianship, your daughter would still have her parental rights, even when you're appointed legal guardian. But your grandchildren would be in your care, custody, and control until they reach the age of 18 or until the court decides otherwise. Rosa's daughter can petition the court in the future to give her back custody of the children. But the court will determine what is in the best interest of the children.
Hi, you guys good?